All right, and we are here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation, so I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
So we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are appear in court every time the case is set on docket, no new law violations, install a IID device in a vehicle, no driving without permission of the court, no drugs, no alcohol, plan to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event that occurred on January 16th of 2020.
This right here is the heart of every bond hearing: flight risk and danger to the community. The defense is trying to narrow the judge's focus: less emotion, more procedure. If the car can't start, the argument goes, how can the public really be at risk? But notice how carefully the lawyer is walking here, because one wrong framing, and this turns from mitigation into excuse-making.
Wants a copy. I have a copy to show them, but sure. So, Your Honor, just going to the very first order. As Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe, were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, one of the two main points of determining what kind of bond, both the conditions and amount, are will they return to court and community safety. Here, my client, who's being accused of DWI, wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf Well, we
We'll
could,
we'll get
I
there.
mean, we can call that, Your Honor, but
We are.
sure.
Hey,
Judge, I spoke with defense counsel today and he said that he was not requesting to have anybody come here to testify to the scram device.
we have Felicia that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did
So.
that. So that's, yeah.
Please.
Yes, Your Honor, we would call pretrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended pretrial supervisions and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, what I'm showing you, do you recognize this?
Yes.
Can you tell us what this is and what are the conditions that are checked?
These are,
Sorry, could you repeat what you just said?
sorry, I said I don't know if she needs that. It was an extra paper.
Okay. I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new, law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain, we do have a curfew of 9 p.m. to 6 a.m. and then a scram device to be installed.
And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
Let's pause for a second. A scram device doesn't test breath, it detects alcohol through the skin over time. That's important. This isn't a single blow like a breathalyzer. It's data, graphs, dissipation curves. And here's the tension. The state is leaning on the technology, while the defense is quietly planting doubt about who really understands it.
The state is trying to ask her to testify as far as her, are you trying to establish her as like an expert on scram?
And I was not trying to establish her as an expert, just from her experience, what the scram device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as, that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there is a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's been marked as State's.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, state, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And now I'm showing you what we marked as State's Exhibit 6. Can you please tell us what this is?
So this is a scram report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this very accurately depicts a scram for anybody that says it is.
Yes,
We will tender defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date?
yes.
Defense received it, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the scram was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the Scram device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you is State's Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a scram analyst.
Thank you, we pass the witness.
Okay. All right. Good morning. I just want to, if you could turn to, I believe it was the State's Exhibit 3, I think, for the Scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
No.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So
thread that was provided.
let me, sorry, that was a poorly phrased question.
I'm sorry, I
No,
don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you?
This is classic courtroom chess. The defense isn't saying the scram is wrong. They're saying this witness might not be the right messenger. Theory versus hands-on experience. It's not about catching her in a lie. It's about whether the judge feels comfortable relying on second-hand expertise when someone's freedom is on the line.
Okay. And do you have any sort of, have you ever worked for Scram systems?
No.
Have you ever had any special training in Scram systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago
Mhm.
to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but
And
not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper,
Mhm.
environmental factors versus consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the Scram device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a Scram and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's Scram device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so, one second. So is it fair to say that you've been thoroughly trained on the theory of Scram device and alcohol detection?
What do you
Is that fair to say? That let me rephrase that. So, you don't have any actual technical experience with how the Scram device detects alcohol in someone's skin. Is that fair to say?
think?
I don't want you to think. Is it yes or
I
no?
I still don't understand.
I'm trying to understand too.
Do I not understand how a scram device works, or have I not for myself and?
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I
We
partially
did
wrong
go
about?
over, yes, reading the grounds, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially as well with tampers, environmental factors with that, makeup
Mhm.
or, placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no withdraw that question. So I'm just saying there was no actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined the report for that.
Well,
And also reviewed some of the peer-reviewed articles.
well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want to further knowledge. But, what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? You agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Objection asked and answered.
Okay, just, let's go.
All right. Just ask the question. I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that all right, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scram device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scram device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. and this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated those orders, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay,
Yeah, Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court, and in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just taking into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time
Just
is
so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking.
And here's the moment everything changes. 3 violations, multiple chances. The judge is no longer weighing hypotheticals. She's weighing credibility and patience. When a judge says, "I've bent over backwards," that's courtroom language for the rope just ran out. At this point, the decision is less about data and more about compliance.
I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody, on the test itself, on whether it tests cannabinoids, which delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it, you know? At some point, I become an enabler, and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you're revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not cheap, Your Honor. So if you could keep that into consideration on that.
It's, you know, and it's
I understand.
representing him in Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Okay.
Yeah.
But tell him this, that he's lucky that he didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't. Mr. Gutierrez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Sir.
On January 31st, 2025, it says the officer observed a Dodge Challenger run the red light in an attempt to make a U-turn in a sudden acceleration and almost strike a vehicle that was traveling north and had a green light. The vehicle had to perform an emergency maneuver to avoid the Dodge, but did not stop and continue northbound on Westlake Houston Parkway. The officer initiated a traffic stop, and the defendant was pulled over for reckless driving and running the red light.
So you said he's at a stoplight?
Yeah, so he ran the red light in an attempt to make a U-turn while somebody else had a green light and almost struck the other vehicle. And he
Okay.
also had 0.20 grams of Tylenol on him. That's what the DIN says.
So I'm going to find probable cause now. Do your diligence, get the video. If you show something different, come back, let me know. We can always revisit probable cause at a later time. Okay? Do you see whether he has a Texas driver license, please? Okay. Mr. Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to drive in a reckless manner, no racing, street takeovers, donuts, anything of this manner. If I find that you do, that you put my public in danger, I'm going to revoke your bond, put you in jail. So you understand?
Yes, sir, I do.
Eligible judge.
Okay. Now he's on felony probation upstairs. Are you familiar with this?
Not with the felony probation judge. Have they, does it show they filed
He's,
a MAJ yet?
I don't know. Let's look. You're on probation. It looks like it may be a second or first degree felon. Yeah, second degree felon. Let me see. So just be on the lookout, it's very well they may file a felony warrant now. He's already had one MAJ dismissal. So be on the lookout, sir.
Sir.
So do you mind filing those conditions, please? All right. You're also, Mr. Gutierrez, not allowed to drive unless you have valid liability insurance in your name. If I find that you drive and you don't have car insurance, likewise, you'll end up going to jail. You understand? Now you have a lawyer. Because you have a lawyer, I'm going to waive your appearance, but it is your responsibility to stay in touch with Mr. Henderson, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. For now, I'll have you sign a wreath of Victoria. We'll have you take a sit in jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys.
Just you?
Got it.
All right. He's in jail.
Good morning, Mr. Concepcion. So you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. Is it on docket today or not?
Not on docket.
Okay, that's what I was, okay. So it's a straight probation as well.
It is, Your Honor. I asked for deferred, but we settled on straight. He's on deferred on a felony.
Perhaps that's why. All right, let me see.
He did miss court a few weeks ago, Your Honor, so there was a warrant.
Is there a felony warrant right now?
Yeah, there should not.
Sure.
They reinstated like his probation on the 9th of January.
And he has been meeting with his probation officer.
You need to understand something, that you're on probation for an extremely serious case. You're looking, is it a first or second degree?
Second degree.
I think it's second.
Second degree probation.
You need to understand these types of probations, when you get revoked on a second degree, you're usually looking at double digits, probably 10 to 12 years in prison. Do you have any clue what they would do to you in prison? No, you don't. Have you been to prison before?
Sir.
Your potential, how many times have you been to prison? Once, twice?
That's
You
once.
could be a potential 15 to life case from now on, man. Really. Not only that, it's a 3G. You get revoked, you're doing half the time before you're even eligible. There's only so many times that they're going to reinstate before they start throwing the book at you. You know what I mean? Really.
Yeah.
So you've worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 6 months. As part of the agreement, the only thing that you have to do is stay clean. Literally, it's the only thing you got to do. Can you do it?
Yeah.
If you don't, I'm going to put you in rehab myself. Really. Not only that, but depending on what you're taking, you take too much of it, all you're going to do is put your lungs to sleep and you end up dying. We see it happen here all the time.
Sure.
You build up that tolerance, you keep taking it, and then, you're chasing it, right? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this, there's no changing. You understand?
Yes, sir.
This is what you want to do. I got a figure of all your criminal history here. I wonder how much of it is related to. You're young. Get off. Do something else.
I just turned 30 years old.
Really. And this,
Yeah.
all right. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to send you to the agreement. If you want any help, come back and we can help you out. All you got to do is ask. But if you go out there, if you take off, you pick up a new case, you test positive, I'm going to put you in jail. I'm going to issue a warrant for arrest. We're going to bring you back. We're going to have a hearing. And if they prove it to me, you're looking at a year in jail. Do you understand?
Sir.
All right, man. Good luck.
Thank you, Your Honor.
Got it. Are you Miss Somali Lerner? Yes. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 30th, 2025, officer ran a check on a vehicle in Harris County, Texas without proof of financial responsibility. The vehicle also had a defective brake lamp. The traffic stop was initiated. Defendant driver ID'd by a Texas driver's license stated she did not have insurance for the vehicle. Officer observed defendant to have thick
Bloodshot eyes or thick slurred speech.
Speech and the odor of marijuana emitting from inside the vehicle.
Officer asked defendant when she last smoked inside the vehicle. Defendant stated she had a few roaches inside the vehicle. Probable cause search was conducted. Officer found 0.103 ounces of marijuana. A DRE officer arrived on scene and conducted Romberg test. Defendant estimated passing of 30 seconds and 12 seconds. Shows D is in an elevated state. DRE also observed thick SS, FSTS conducted 6.6 HGN, 3 out of 8 on walk and turn, 2 out of 4 on one-legged stand. When defendant was arrested, D repeated the phrase, "Oh my God," several hundred times. Officer knows from ARIDE training that this is a symptom of dissociative anesthetic. The SC read, D refused to sample the breath, blood, search warrant signed and executed.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can you look to see if she has any prior DWIs? Number one. Number two, if she has a valid Texas driver license, please.
No prior DWIs.
Okay,
And your driver's license.
great. Okay. Ms. Lerner, like I said, no alcohol, no drugs. I'm going to randomly test you. Do you have the ability to hire a lawyer or would you like a court-appointed lawyer? Okay, I need you to fill out an application for me. I'll take a look at it. And then for now, I'll also have you sign a receipt with Victoria. I'll later have you get with Felicia for your bond conditions and then I'll have you meet with a lawyer. in
Their
the
license
being suspended.
I'll let you talk to a lawyer about it. I can't give you legal advice. No, assuming we give you a lawyer, you can ask the lawyer and the lawyer can advise you properly.
I need to start working. I lost my job.
Just, yeah, talk to the lawyer and they'll be able to advise you properly. I haven't, as long as you have a valid Texas driver license and you have liability insurance, I'm not taking away your privilege to drive. Okay? So, yeah. All right, let me have you get with everybody and then we'll have you speak to someone here momentarily, okay? Please. Matthew Leonard.
Yes, sir.
So Leonard, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on 4/12/2023, officers were dispatched.
Hey, yo, hey.
Did not have story about that right here.
On 4/12/2023, officers were dispatched to a crash involving a bus and a car at the 1700 block of Travis Street. Officers made contact with the defendant who was slumped over in the driver's seat of the car. Officers observed the defendant to have red and glassy eyes, strong odor of alcohol in the breath, SS, and slurred speech and incoherent speech. Defendant told officers that he was drinking 211's beer at his house and last drank 2 hours ago. Defendant was taken to the hospital and diagnosed with a minor brain injury. Officers got a blood warrant. There was a blood draw completed at JPC.
Then, so what, do you have the results? Hold on a second, let me see.
No, not yet.
No, Judge, we don't have any blood results
I see
yet.
it.
For some reason, there haven't been any to-dos done on the case. I'll submit them immediately. That's.
Well, it looks like it's because it was a 2B, that's why. So it's from April of 2023. Looks like there was a blood of a 0.198. Okay, Mr. Leonard, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs or unprescribed controlled medication, I'm going to randomly test you. Because it's a second offense, I'm now ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. Miss, can you run his license, see if he has a valid Texas driver license, please? Do you have the ability to hire a lawyer, sir?
How much time can I pass this? Because I'm in the process of getting my ID and everything. Because when I got locked up, I didn't have my wallet. They threw it away or something. You know what I mean?
Would you like a lawyer, sir? I can give you a
Yes, sir.
lawyer today.
Yes, sir. Yes, sir.
Okay, so understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm going to randomly test
Yes,
you,
sir. Yes,
and
sir.
you're going to have. Do you show a Texas driver license?
That's all it is.
Okay. All right, sir. So what I'm going to have you do now is I'm going to have you sign a bunch of paperwork with Victoria, Felicia, and then I'll have you meet with the lawyer here momentarily. Okay,
Yes, sir.
please. All right. Good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. What would you like?
No, we're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 bond has been set in the case here in Harris County. We would respectfully request bonds in the amount of $20,000 on the 3 fugitive warrants. And let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, we'd be asking for no bond.
I told him beforehand, we've visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it just, it's so much baggage. He scares me, you know? And
He does have, he's kind of been a resident of this area, you know, for 25 years. So
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this, you know? So yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know? So I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, but it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
And I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick. So, okay. You guys let me know what you'd like to do. Thanks. Hi. Hey. Happy Friday, man.
Happy Friday. We are here.
Who do we have here?
We have Herman Riley, Judge, Riley.
Morning, Mr. Riley.
Requesting bond.
Okay, Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, moon, stars, everything here, but that really tells me who you are. So, Dave, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the.
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA. I believe it's a 2B warrant.
What's a 2B? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
Yeah, I know.
So let's not talk about the case, because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
Myself.
My only concern is, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working. If I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already. So as soon as I go up there, he gonna walk me out. I'm gonna take care of the bonding and everything. But I just want to let you.
It's set there.
I'm checking that right now, Judge. No, there's no bond set, which means they'll set one as he self-surrenders, but I don't know what they would set it at.
So typically the way it works is if we set you a bond, give you 14 days from the date of your release to go turn yourself into Louisiana. If you fail to go do that, you have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is that state requests a bond of $7,500.
Judge, we'd request a bond set of 1,000.
Big difference.
It's pretty big divide, Judge.
So the problem is that because you're a fugitive, right? You're an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him. Let me know, what's something that you guys.
He told me he could make $1,000 bond.
Yeah, I think 1,000 is too low.
That's the amount that he can make.
That's too low. I mean, that's what we do on normal cases, not just,
Unless I get new information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, unless I get new information.
I don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500. Okay. And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Have able to reach out to your folks, your family, to see that's something that whether you guys can make it.
And under 2,500.
This is not I'm not going to negotiate with you, dude. This is just that 1,000 on a fugitive case with this type is just too low.
And also, just binding counsel in the court is that even presuming that he's able to make this because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll have to take that into consideration.